Hey y'all, Rob here with ATX Legal, and today we're going to be talking about different ways you can get your assault family violence case dismissed pre-trial. In some cases, it might even be easier than you think. If you have a pending DV charge, you're going to want to hear this. Now, of course, I've got to hit you with that caveat. Every case is different. I am not speaking to your individual facts. If you would like legal advice on your specific situation, you can visit us at atx.legal and fill out a contact form. There's a link in the description below. Now, you might have heard the expression that you catch more flies with honey than vinegar. And in my experience, a lot of times in law, that's the case. So I always start with that honey approach, and I try to work with the prosecutor to come up with a deal that we can both work with. Now, if that doesn't work, we sometimes do have to switch to the vinegar. So what does that mean in the context of domestic violence cases? Well, first I'm going to try to reach out to the complaining witness. The complaining witness is the person who's alleging something happened. And maybe that person didn't even want the police to be called, or maybe they're not wanting to pursue charges. So my first step is to talk to them and see if we have their support. If we do have their support, we can get them to fill out an affidavit of non-prosecution, or we can have them call the prosecutor and explain their side of the story and explain that they do not wish the charges to proceed. Now, the prosecutor doesn't have to dismiss based on the input of the complaining witness, but a lot of times they'll get that input, they'll take it to heart, and they will dismiss the case on that basis. And the second way we can use that honey approach is to complete all of your classes. Now, when you get bond in an AFV case, you're typically given instructions to go sign up for classes, you take an assessment, and they'll assign you for a 12-hour class or sometimes a 36-hour class, sometimes even a 52-week class that you have to complete. Now, nobody likes completing these. They're pretty boring. You can consider it a type of punishment, but if you can go in and complete those classes and have that certificate that it's completed, it can help in the plea negotiations and sometimes tip your case over and get that case dismissed, which is what we all want. Next, I can present mitigating evidence to the prosecutor. And this can be evidence that you're a good person. It can be character evidence from your employers, from your friends. You can show evidence that you are taking good care of your children and your family, that you're complying with all protective orders, if that's one of the conditions of your release, and just in general that you're not a danger to society, and that if this assault happened at all, it was a one-time event and it's never going to happen again. So if you can show that to the prosecutor, and the prosecutor can rest assured that you're not going to be picking up new charges after your case is dismissed, they're going to be more likely to do that. And lastly, and sometimes in conjunction with the other methods, I will suggest the FVIP program. That's the Family Violence Intervention Program. And that's a program in Travis County where you can show over the course of 4 to 6 months, sometimes a year, that you have not picked up any new criminal charges, that you've completed all those classes we talked about, and at the end of that period, you actually get your case dismissed and you can have it expunged. And in most cases, if it is offered, I do suggest that my clients accept that offer. It gets you to that dismissal that you want, and yes, you do have to jump through a few hoops, but for most people, that's worth it. Now, let's say we've tried all the above approaches and nothing's working. The prosecutor is still coming to us and saying, we need you to accept a conviction. Maybe it's just probation and no jail time, but they're still wanting that conviction, which would come with a family violence finding. And if you want more information about why that's so bad, you can check out the other video here, or there's a link in the description that talks more about the family violence finding. But for now, just realize it's something that you want to avoid. And if that's the only offer the prosecutor is coming at you with, you typically want to reject that offer and keep working on plea negotiations. Always talk to your lawyer though, every case is different. But now we've gotten to the point in plea negotiations where nothing's working yet, and now it's time to use that vinegar approach that we talked about earlier. Now, by that I mean we're gonna start going on the offensive. Is the prosecutor's case weak? Well, we wanna attack that weak evidence. Are there witnesses who might be lying? We want to attack those witnesses. We want to make sure the prosecutor knows all these things in plea negotiations if we think we can get to that dismissal. Now, there are situations where you want to hold that evidence back, spring it at trial. If you're fairly certain the case is going to trial, you don't want to show all your cards to the prosecutor. That's why it's important to listen to your attorney. I'm giving you general advice. This is for educational purposes. There are cases where you want to do the exact opposite of what I'm telling you, but there are cases where you want to show those cards, let the prosecutor know what the weaknesses are in his case so that he will get to that dismissal pre-trial. And often we need to attack the character of the complaining witness. Many of these cases come down to he said versus she said, and the credibility of each party is going to make a big difference. So if the complaining witness has a criminal history, like we said before, if there's drug use, Has she made allegations before that proved to be false? Has she ever lied, and can we prove that she lied? All of these things are going to factor into the prosecution's case, and they're going to do that math in their head. Is this case really worth going to trial, or is this a case that is a loser because of all these problems in their case? If they feel like it's a loser, they might offer that dismissal pretrial. Now let's say we've tried all of the things we talked about earlier in the video and nothing has worked. The prosecutor is still wanting you to sign on the dotted line saying, I am guilty of a family violence charge. Now in that case, a lot of times the only option is to set the case for trial. Now that doesn't mean we actually go to trial. Remember, this video is about getting the case dismissed pre-trial, but setting the case for trial can have its advantages. First, it makes the prosecutor give a real hard look to the evidence. To this point, they might not have called all the witnesses, they might not have talked to the police officer, they might not have seen some of the holes in their case that they'll only recognize by giving their case a good hard look. Secondly, it puts pressure on everyone involved, including the complaining witness. They're going to have to come testify. Maybe they never really wanted to do that in the first place. And if they're unwilling to testify, a lot of times that's almost automatically going to be a dismissal. Not always, but in many cases, the prosecutor does need that testimony of the complaining witness to go forward. If they're not available, or if the prosecutor can't locate them, they might dismiss the case, but only after you've set it for trial. And just because we've set the case for trial doesn't mean that we've forgotten about all the tactics that we talked about earlier. We can still present mitigating evidence. We can still offer that family violence intervention program on the eve of trial, and maybe the prosecutor will say, you know what, we don't have that strong of a case, but if we can get him into the FVIP program, we're going to go ahead and go that route. So there's a lot of advantages to putting that pressure on the prosecutor by setting the case for trial. Now, if none of those work, maybe it is time for trial, and the only way we get that dismissal is not a dismissal at all, but an acquittal in front of a jury. And that's the decision to make the day of, taking into account all the factors of the case, and that's not something that I can talk to you about in this video. That's something you would talk to your attorney about and make that decision on the day of trial. Again, this is not legal advice, but you can contact us at the link below. I'd be glad to talk to you about your case with a no-cost consultation.